I want to pursue the line of questioning that Senator Franken began, perhaps beginning with you, Professor Wu. As you know, the FTC recently investigated Google, and you remarked on the investigation and its close with a relatively lenient remedy. Some have said a non-remedy. And a number of people, including experts, criticized it in 2013 because of the lack of formal charges. And the allegation there was that Google essentially was presenting search results in a way that benefited itself more than consumers. I think that's a somewhat oversimplistic way of characterizing a more complex set of allegations, but you and Professor Luca of the Harvard Business School examined whether consumers preferred Google search results or more unbiased organic search results, and you found that consumers preferred the unbiased organic search result by a very significant margin, perhaps not surprisingly. I wonder if you have followed the practices of Google since then, and whether there has been any change in conduct.
Right. So I will say one or two things about that. So one of the, I think, challenges of the FTC's investigation of Google is that there was not at the time strong evidence of consumer harm. Google made the argument, and I think it was a fairly convincing argument, that its improvements, universal search as it was called, was in fact preferred by consumers and overall better. And I think that was one of the reasons that the case was closed. I think our subsequent research and using more advanced methods suggests that, well, some of what Google is doing, particularly in the local thing. So I don't want to say this generally. I think if you do a search for weather in Washington, you find out it's cold instantly. That's quite obviously good for consumers. If I had known that, I would have brought a bigger coat. But I think that what has been proven is that in certain areas, Google is manipulating its search in an anti-competitive way. And I think that evidence makes a difference. And I think Google is at this point in a different position than it was then. So maybe that's all I want to say. I think there's stronger evidence of consumer harm now than there was when the FTC did the investigation.
In fact, it caused you to change your view of the situation, did it not?
The harm, I felt differently after seeing the results of the testing showing that there was much more evidence of consumer harm than we had access to at the FTC. Yeah.
Shouldn't the FTC change its view as well?
I think it would. I can't speak for inside. I think it would be worthwhile for the FTC to pay attention, particularly to the local market. I understand why they're, having closed an investigation, it might not want immediately to get to it, but I think it should seriously consider the new data and ask whether what's going on in local, in particular, is anti-competitive. I think it's clear that there is, and this isn't only a Section 5 question, but a Section 2 question as well, that there is a company here with a dominance, and it is having a strong influence on competition, and so therefore has some of the trademarks of a traditional antitrust investigation.
To most consumers, local searches are the most meaningful kind of searches. They don't search in San Francisco for a good restaurant when they live in New York.
Yeah, that's right. No, I think local has become an incredibly important part, and is sort of the nexus of, as you said, how all businesses are found. And the idea of one, not only online businesses, but if you're looking for a good restaurant, you're looking for a good place to get a beer or whatever, get your shoes fixed. And so local is turning into an important thing, and I think it is an area that should have vigorous FTC or Justice Department oversight.
So let me just conclude with this question. If in fact Google is preferring its own properties, and if in fact there is consumer harm, which was not apparent to you before,
Right.
shouldn't there be a basis for Section 5 enforcement action?
Like, as with everything, these cases are complicated, but I think the Federal Trade Commission should be looking at this, or the Justice Department, or both.
Do any members of the panel disagree?
Well, Senator, I hate to disagree with a colleague of mine in bringing the Microsoft case some 15 years ago, but I think I do if I understand the facts, and I'm relying on this colloquy for the facts. Surely the fact that consumers would prefer a slightly different product cannot be the basis for prudent government intervention.
That's correct, and I'm interrupting you only because, and I apologize, I almost never interrupt a professor, not to mention a former esteemed colleague, but it's not just consumers preferring or wanting one service over another. It's Google, in effect, denying free choice or preferring one of its properties. Am I correct, Professor Wu? In other words, if you're relying on our colloquy for the facts, there's more than just what you've just stated.
Well, I think you're not in a position to have other choices. So it has some similarity to the Microsoft situation in the sense that also because, I mean, we don't have the full facts in front of us, but some of these sites may threaten may ultimately serve as a threat to the search paradigm, which is Google, where Google has the most market power, and so they're concerned there's a certain monopoly maintenance kind of aspect to it, similar to the Microsoft case. We haven't briefed all the facts here, so I think it's
I would stress we don't know all the facts, and I am putting both of you in a somewhat unfair position by asking you for views, but I'm happy to let you proceed. Sorry to interrupt.
Well, I mean, all I was going to say is that surely the fact that consumers would prefer a different product or set of circumstances from their supplier can't be enough. We all want to get the same product cheaper or with more bells and whistles attached to it. And if the seller is imposing a different product on the consumer because he finds it more economical to do so, seems to me that's how the marketplace is supposed to work. If the facts are that a monopoly is using some anti-competitive means to exclude a rival and aggrandize its market power, then of course we have the making of a Section 2 case, such as some case you and I and others brought against Microsoft. But that doesn't require Section 5.